नीना, ये हो तो गया, पर ये है आवाज, ठीक है, ये
क्लियर है सर। श्रीवास्तव सर, आपकी आवाज क्लियर है।
हाँ तो आ रही है। यस, कैन यू हियर मी?
यस सर, वी कैन हियर यू।
ये बहुत स्लो है आवाज।
आपकी आवाज क्लियर है डॉक्टर
अच्छा,
श्रीवास्तव।
दैट्स फाइन, गुड, फाइन। ठीक है, राइट,
यस,
ठीक है।
उसको मत कर। तुम बना दो।
Right. Okay. I can see you now. Right. Hello, Dr. Astana.
Shall we start, sir?
Yes.
Maharishi Mahesh Yogi ji said, the important thing is to be able at any moment to sacrifice what we are for, what we could become. A very good morning to our esteemed speakers, learned panelists, and all the participants present in this much awaited seminar of the year. Hello everyone, I am Isha with my co-anchor Yash. We extend our heartfelt welcome to all of you on the behalf of Maharishi University of Information Technology in this international conference on family law, contemporary challenges and solutions. Maharishi University of Information Technology was established under MUIT Uttar Pradesh Act number 31 of 2001, notification number 573 dated 6th October 2001. The university campus is at PO Maharishi Nagar, District GB Nagar, Sector 110, Noida, Uttar Pradesh. The main campus is in Lucknow. The university is reputed to disseminate quality education. His Holiness Maharishi Mahesh Yogi ji was the first chancellor of the university. MUIT has been recognized and included in the list of universities maintained by the UGC under Section 2F of the Act 1956.
Now about the law school. Maharishi Law School was established in 2017 under the Maharishi University of Information Technology. Maharishi Law School is one of the premium institutes managed by the Maharishi Society. This institute is known for its teaching methodology and offer its undergraduate and postgraduate programs. The School of Law also encourages the students to participate in academic events like moot courts, debate, quiz, seminars, conference, workshops, etc.
We are grateful to all who have accepted our invitation to be the part of this elite event. It's our holy tradition to worship our Lord Ganesha before any important event. So I would like to invite our students for dedicating prayers to Lord Ganesha. Now, I would like to welcome Anu ma'am for giving a brief description about conference.
Good morning, one. Good morning, one and all present here. I would like to extend my warm welcome to everyone present here, especially our honorable our chancellor sir, our vice chancellor sir, DG sir, advisor sir, honorable this is Mohan sir, Professor S.C. Srivastava sir, and our honorable guest of honor, who could take out time from their busy schedule to grace this conference with their benign presence. This conference has been organized to contemplate and present our ideas about probably the most delicate limb of the Indian judicial system, the family law. Though family law lays out and protects the rights and the responsibilities of family members across a wide spectrum of situations, as it is designated to be a framework that provides a basis for the achieving fair and the equitable results for all family members involved, whether they are adults or the children. But it still remains the most sensitive arena of debating and most emotionally charged area of law. Because at the end of the day, we are soliciting failing relationships and broken families, and whose effect goes beyond just that generations. Mumbai, which tops the list of the maximum coronavirus cases in the country, also saw the highest number of the divorce cases being filed during the lockdown period. Post-corona, the city saw a nearly 3/4 increase in cases of pertaining to divorce and the women-related issues being filed. From an average of the 1,280 cases in a month, their number went up to the 3,480 during the lockdown. Delhi was at the second spot, thus making family law and its related issue the focal point of the lot of the debates across just not the country but the worldwide. This is also the primary reason why Maharishi Law School has taken this specific legislative branch of the topic of discussion for this conference. Now, I would like to welcome our Honorable VC Sir, Professor Dr. B.P. Singh, to say a few words before we commence with the conference. Thank you, sir.
Good morning, everyone. Myself, Dr. Bhanu Pratap Singh, welcomes distinguished guests, faculty members, and participants joining us for this two-day international conference on family law, contemporary challenges and solutions. I believe this conference will help all the participants to grasp information to enhance their knowledge about family law, its challenges and its solutions. On this note, I would like to invite Honorable Chancellor Sir, Maharishi University of Information Technology, Sri Ajay Prakash Srivastav ji, to kindly inaugurate the session.
Good morning. Thank you, VC sir. First of my regards to Justice Honorable Justice Mohan and Professor S.C. Srivastav sir for joining this conference and encouraging our students and faculty for a very important issue on which is a big challenge, as Anu ma'am said, at this time during this unprecedented situation that the world is facing, and the family problems are increasing, and that's why it's very timely that we discuss on the family law. As we all know, the family is the smallest unit of the society, and a happy family makes a happy society. When the set norms of the society which govern the family, which have been there for ages and different from different countries or different cultures, when those set norms are not able to unite the family together, keep the family together, keep the family happy, then law has to enter. The law of any land will have to enter that family and try to find a way that the family can be again either reunited or separated with whatever possible legal possible methodology is there. So it's very necessary that a family is always either live together or live separate, but they are always happy, because that will constitute a happy society, and that will create a much better world for everybody to live in. The law has to enter only at that stage when we cannot find a way to resolve the issues. And fortunately, in our country also, in many countries also, the legal system is there of mediation and arbitration. Mediation is generally very helpful, especially in family cases, family law situations where some elderly person or some well-established person in the society or a senior lawyer or senior retired judge, they can help resolve the situation. Then the family doesn't have to go to court, because unfortunately in our country, if you go to court, it takes long time to find a solution. So I think this conference, I think this matter will come up, that what is the best way to resolve the family disputes. As we can see that the challenges and solution is the title of this conference. Then the biggest challenge that I know from my non-legal background that I face is the time taken to resolve an issue in a court of law. So if we can overcome that challenge by finding different methods of resolving disputes, that would be much better to come to a conclusion. And as everybody knows, long time ago when there was a issue of biggest fight in our country was the Mahabharata, Kaurava or Pandav, and Lord Krishna was there, and he's not powerful because he was the incarnation of the Lord Vishnu. But still, he said the fighting is not the solution. The solution is the peace. So he went himself as a peace messenger of peace. Of course, it didn't work out that time. That was the situation that time. But it's always the dialogue between the two parties, two angry parties. Dialogue between the parties is always a best solution. So as you will find in this conference, 2 days, different discussions by all our learned speakers and guests, that the best way to resolve any situation, I think the solution, the outcome will come out, that the best way to resolve any situation is of course, dialogue between the two parties, and that is called mediation in legal terms. But if we have to go to the court, then of course the laws are there, and that's what we will deliberate in today's conference. I wish all the success to the conference, and I thank all the organizers of the conference, Professor Asthana, Professor Anu ma'am, and all the students that have been organizing this conference. All my best wishes to them, and all my best wishes for the conference. Thank you very much.
Thank you for enlightening us with your kind words, sir. I feel privileged to have such a distinguished chief guest, Honorable Mr. Justice. Now, I would like to invite our Vice Chancellor, sir, for facilitating the guest.
Very good morning to all. VC sir, मैं request करना चाहता हूँ कि that all the dignitaries should unveil the souvenir today as we are having an international conference. VC sir, over to you.
Thank you, sir. I request all the guests kindly unveil our souvenir to inaugurate the session. It is requested to everyone kindly participate in the ceremony.
Now you can open.
Thank you everyone for joining the session. All the participants, all the guests. It is a great honor to all of us. Such type of dignitaries are with us in this inauguration session of this international conference. It is great honor to Maharishi University and also Maharishi family. Thank you, everyone. Thank you, sir. Thank you, Asthana, sir.
I feel privileged to have such a distinguished chief guest, Mr. Justice Mohan, former Chief Justice of Sri Lanka, among us. I may be permitted to give a brief introduction about his accomplishments, professional attainment, and his field. Justice Peter Mohan Mathri Peres is a former Chief Justice of Sri Lanka. He previously held the post of Attorney General. After qualifying, Peres worked for senior lawyers Daya Pereira and DRP Gunatilak. He joined the Attorney General's Department in 1981 as a state counsel, later becoming a senior state counsel. He was appointed as Attorney General on 18 December 2008 and was appointed Senior Legal Officer to the Cabinet in September 2011. He became Chairman of Ceylon Bank in April 2012. He is permanent representative of Sri Lanka to United Nations Organizations, New York. Sir, I would like to felicitate you with virtual memento on behalf of Maharishi University of Information Technology.
Thank you.
We rarely get this kind of opportunity to listen to the words of great personality like Mr. Peres. So let's have the privilege of listening to him. It's my honor now to invite the Honorable Justice, Mr. Mohan Peres, to address us. Hand over to you, sir.
Thank you. It's the very small hours of the morning here in New York. It's 45 minutes past 12. But I thought it was a privilege to be with you this evening, at least this morning, simply because I take great delight in being with students as much as I'm with my UN community here. It's equally exciting. May I thank, first of all, the Maharishi School, the Chancellor, the Vice Chancellor, the faculty, the academia, Dr. Asthana particularly, to whom I could say no to, and the most important of all, you, my dear students. The topic of today, I think, is very timely and perhaps something that has been visited with great relish even here in the UN because of the concept of the family. My dear students, the United Nations General Assembly, in its resolution 44/82 of the 9th of December 1989, declared 1994, there's a little bit of history, as the International Year of the Family. The theme of that year was family, resources, and responsibilities in a changing world. Its motto, building the smallest democracy at the heart of society. Look at that wording, building the smallest democracy at the heart of society. That's where the heartbeat of our communities really continue to beat and give life to communities, my dear students. So the United Nations Commission for Social Development was designated the preparatory body, and the Economic and Social Council, in which I participate even today, as the coordinating body of that particular year. You will appreciate, my dear students, that the family constitutes the basic unit of society and therefore warrants special attention. Hence, the widest possible protection and assistance should be accorded to families so that they may fully assume their responsibilities within the community. Pursuant to the provisions of, the Universal Declaration of Human Rights, the International Covenants on Human Rights, the Declaration on Social Progress and Development, and the Convention on the Elimination of all forms of discrimination against women. Families, my dear students, assume diverse forms and functions from one country to another in their social conditions. Consequently, the International Year of the Family encompasses and addressed the needs of all families. As I said before, just a few minutes ago, the family is a key social institution in all societies, which makes it a cultural universal. Similarly, values and norms surrounding marriage are found all over the world, in every culture. So marriage and family are both, you will appreciate, what we call cultural universals. So the United Nations will seek to promote the basic human rights and fundamental freedoms to all individuals by the set of internationally agreed instruments formulated under the aegis of the United Nations, whatever the status of each individual within the family, and whatever the form and condition of that family. Policies will aim at fostering equality between women and men within the family to bring about a fuller sharing of domestic responsibilities and employment opportunities, and the Constitution of India reflects a similar ethos. My dear students, why do we need to have family laws? Family laws encompass the broad set of rules that are in practice regarding family matters such as marriage, divorce, inheritance, adoption, etc. There are some legally enforceable rights and duties that arise when one gives legal validation to the status of interpersonal relationships. Now, you will appreciate that the justification for having laws that affect the most private aspects of our lives is to ensure protection of individual rights and to uphold certain norms that are essential to human dignity. Another reason is that laws act as agents of social change and may succeed in improving the status of individuals in society. You might now ask me the question, where are the legal principles embodied in these laws derived from? In other words, where is the source of authority? In India, there are 5 broad sets of family laws in India. You know it better than I. Hindu law, which governs all Hindus, as also Buddhists, Jains, and Sikhs. Muslim law for the Muslims. Christian law for the Christians. Parsi laws for the Parsis. And secular law, that is the Special Marriages Act. The religion-based laws are derived from religious texts. These laws have also been amended from time to time by parliamentary legislation. My dear students, you know that Hindu law has been substantially altered on account of extensive legislation enacted post-independence. Christian and Parsi laws have been changed more recently in the last decades through legislation. Muslim law, however, has been the least modified and hence retains most of its text and interpretation of the times when its religious texts were written, except perhaps for the recent judgment on the triple talaq. Now, needless to say, your beautiful country is a land of diversities with several religions. The oldest part of Indian legal system is the personal laws governing the Hindus and the Muslims. The Hindu personal laws have undergone changes by a continuous process of codification. The process of change in society has brought changes in law, reflecting the changed social conditions and attempts the solution, of social problems by new methods in the light of experiences of legislation in other jurisdictions all over the world. The Muslim personal laws have been comparatively left, as I said before, untouched by legislation. I would therefore recommend that this conference would seek to assess, to evaluate, to analyze and examine how different codified Indian family laws actually work in the Indian societal setup, how the courts interpret them, and what lacunas exist in these individual family causes. What briefly are the societal conflicts, the law? What is the reality of all this? You will appreciate that all the codified marriage legislations in India stipulate conditions of a valid marriage. The bone of contention, or the most contentious thing perhaps in these stipulations, hovers around 2 harsh realities. And what are they? Age at marriage and the registration of marriages. The principal family law in India, that is the Hindu Marriages Act of 1955, does not render a marriage void or voidable in the event that the boy has not completed the age of 21 years or the girl has not completed the age of 18 years. Child marriages are performed even though the Child Marriages Restraints Act of 1929 provides punishment for the solemnization of child marriages of boys below 21 and girls below the age of 18. To add to the problem, to this date we know that we do not have a compulsory requirement by law for the registration of marriages. Now, this practice, I say, is in harmony with reality. Child marriages cannot be registered due to the non-fulfillment of the minimum age of marriage. Therefore, the violation of the requirement of the minimum age does not entail a nullity of the marriage, since registration is optional and not mandatory. Now, my dear students, the lack of will on the part of the Indian legislature to enact a compulsory law for registration of marriages has not gone unnoticed by your courts. We know the famous case of Seema versus Ashwani Kumar, which directed all states in India to enact rules for compulsory registration of marriages, irrespective of religion, in a time-bound period. The orders of the apex court may perhaps, you might say, opens a Pandora's box. I would leave you to deliberate on those matters in the next few days. The Constitution of India, the fundamental rights to equality, freedom, and protection of life and personal liberty. The equality laws, the equal protection of laws is the touchstone and the spirit of these rights. Additionally, the directive principles of state policy endeavor that the state shall strive to promote the welfare of the people in a social order in which justice, social life, economic and political life shall inform all the institutions of national life. However, the fact remains that in India, when young men and women marry outside their caste or community, it invokes strong sentiments and even terrible consequences, even though there's no bar to intercaste marriages under any codified marriage law. Now, you will probably recall the decision of Lata Singh versus the state of Uttar Pradesh, reported in 2006 Supreme Court Reporter 173, where it was held that the caste system, the court said, is a curse on the nation and needs to be destroyed for the better. Some of you might agree with it, some of you may not, but that's what your courts say. Now, a few more matters before I wind up for your consideration are the unconstitutional extrajudicial clause. I ask you to consider whether unconstitutional extrajudicial courts are a blow to codified law. The two principal family laws in India, the Hindu Marriages Act of 1955 and the Special Marriages Act of 1954, contain three separate sets of separate grounds in a three-tier divorce structure in this legislation. These are the fault grounds, breakdown grounds on non-compliance with judicial separation or restitution of conjugal rights, and grounds of mutual consent. Irretrievable breakdown of the marriage simpliciter, we know, is not a grounds for divorce under any codified Indian family law. I'm asking you to consider the question, is that good enough? I'm also asking you to consider the question as to what effect of custom is on these codified laws. I'm asking you to ask the question, divorce by an irretrievable breakdown of marriage, is it now a necessity? I'm asking the question. I'm not saying answer yet yes or no. I'm just asking, consider the question. Keeping in mind that the institution of marriage in Indian society is largely still a sacrament and not a contract. Remember that, unlike in the Western world. It's a sacrament. It's something sacred, especially under the Hindu Marriages Act. Any major overhaul of the law, in my view, may be counterproductive to the very concept of a Hindu marriage. I'm asking you to ask the next question. Are enforcements of judgments and orders of foreign courts effective? With matters, I'm asking you to ask that question in the context, with matters arising out of family and matrimonial disputes in overseas jurisdictions, with ever-increasing multifold population of Indians migrating and settling in foreign jurisdictions. The link with their home country does not sever, and your courts have made important pronouncements on that matter. Family ties, connections of property and movable assets, and numerous other continuing connections with India often lead to cross-border litigation in human relationship matters. That's something that you must give your mind to. My next question to you, is dowry a social menace? How does the law respond to it? These are interesting questions, my dear students. My final question to you, perhaps, which will probably keep you occupied for the next few years of your degree course. The much talked about uniform civil code. Is it an achievable aspiration or just an illusion? Think about it. My dear students, a series of decisions by the Supreme Court of India in the areas of family laws in the recent past has gone to show that the apex court is motivating a lot of positive and well-meaning reforms which have become necessary over a period of time. So finally, on a net analysis of the various propositions and viewpoints discussed in the last few things that I told you, the ideal solution is perhaps for Indians for India is that there is needed one indigenous Indian law applicable to all communities which coexist democratically. The executive and the legislative arms of the government of India, however, now need to contribute to provide the much needed solutions in the growing India of the 21st century. In this age of virtual reality, the path to progress, in my respectful view, must be charted with harmony at home, not outside India. As the largest democracy in the world, it is my considered view that India has an opportunity to be a role model in various aspects of family laws. Maybe with further changes and amendments, in some aspects, a better role model to emulate may emerge in the Indian subcontinent, where the world can follow. Having said all this, I now must hasten to strike a note of warning before I leave you, that the intention of the legislature and the judiciary is to sustain the institution of marriage. We are not marriage breakers, we are marriage makers, and we are marriage preservers. We protect the institution of marriage because that is the only way. I'm sure my colleagues at the webinar will agree with me that we can probably save the community, the family, and the country at large. So the judiciary is to sustain the institution of marriage within the fallibility of the failings of being human. Of course, we are human. We fail, we fall from grace, but within those failures, we need to strive hard to keep marriages together because that's something very sacred. In this endeavor, my message to lawyers and to those who are wanting to become lawyers, we as lawyers have a duty to act responsibly. We are not marriage brokers, breakers, or kind of money makers. That's not what we are trained for. And certainly that's not, Maharishi is not training you for. I hope not. In this endeavor, we as lawyers have a duty to act responsibly in keeping with the oaths that we have taken, to administer the law with utmost care so as to ensure that justice and fairness ensues. I will leave you with these few thoughts, my dear students, and wish the conference great success and our students every success in their academic endeavors. And again, may I thank you for giving me these few moments to be with you. And I wish you every success. And I hope and pray that our family laws would rise to perhaps the new contemporary challenges that the whole of perhaps South Asia has, inclusive of Sri Lanka, where I come from, so that we will have better families, better communities, and a better nation as a whole. Thank you very much, and a great day of a conference. Thank you.
Sir, could I request you to send the contents of your speech?
I certainly will, of course.
Thank you, sir, because the questions which you have posed to all of us, we will attempt to answer those questions during our technical sessions.
Excellent. Thank you.
Thank you,
Professor Sharma. Yeah, thank you. Would you permit me the privilege of leaving you now because it's about 1:15 in the morning, and I've got to be ready for tomorrow morning sessions. In that tomorrow morning, of course, is a Saturday, and we have a little virtual meeting here. So may I be permitted? I'm very nice seeing you and being with you, and permit me the indulgence of leaving you this in the early hours of the morning of New York. Thank you. Goodbye, and God bless you. Thank you.
Now, it's my honor to invite Mr. S.C. Srivastava, Secretary, National Labour Law Association.
Yes, go on, Isha. Provide biodata of Professor Srivastava.
Okay. May I start now?
Your mic problem or something?
Yes, no problem. See,
No, sir, we would
can you
like
hear
to
me?
participant would like to know more about you, sir.
Okay, thank you.
That will, impact what all we are going to talk. Yes, Isha, can we connect with you?
Yes, sir. He is presently the Secretary General of the National Labour Law Association. He obtained his LLD from Calcutta University, the first person to do so from an Indian university. Starting his career as a lecturer in law school, Banaras Hindu University, he served Jammu University as reader and Kurukshetra University as professor, chairman and dean, faculty of law during 1986 to 88. He served the University of Calabar, Nigeria as professor, head of the Department of Public and International Law and dean, faculty of law. He was awarded the distinction of being National Fellow, National Professor by UGC for 1990 to 92. He served the Law Commission of India during 1992 to 97 and Indian Law Institute as Research Professor from 1998 to 2004. Sir, it's my honor to felicitate you with virtual memento on the behalf of Maharishi University of Information Technology.
Thank you. Thanks.
Thank you for taking out your precious time for us. I request you to kindly say few words for our listeners. It will be a great privilege for us, sir.
All right. So, Shri Ajay Prakash, thank you so much. May I begin? Yes. Mr. Shri Ajay Prakash Srivastava, the Chancellor of the University, Professor Dr. B.P. Singh, the Vice Chancellor, Honorable Mr. Justice Mohan, I think he has left, Professor Group Captain O.P. Sharma, distinguished delegates, faculty members, and I must say, Professor K.B.S. Thana, the Dean of the Faculty, students, ladies and gentlemen. I deem it a privilege and honor to have been asked to be invited to deliver a keynote address and share some thoughts on the International Conference on the Family Law. I would like to start where Justice Mohan left. See, I think one of the most debatable issue on the family law relates to Article 44 of the Indian Constitution. Article 44 directs the state to endeavor to secure for the citizen a uniform civil code throughout the territory of India. If one looks to the history, one may find that the Constituent Assembly agreed on putting the clause of the Uniform Civil Code as the directive principles of the state policy rather than a fundamental rights. In the subsequent year, there were a number of interventions by legislation, judiciary, as well as civil society organizations seeking amendments to the personal law or instituting a uniform civil code. The most notable judgments was the Muhammad Ahmad Khan versus Shah Banu. It is reported in 1985 of the Supreme Court, where he has made a point which is extremely important. And what was said here was that Article 14 of our Constitution has remained a dead letter. There is no evidence of any official activity for framing a common civil code for the country. A common civil code will help, according to the code, in the cause of the national integration by removing a disparate loyalty to the laws which have conflicting ideologies. It is this state which entrusted with the duty of securing uniform civil code for the citizens of the country. See, unquestionably, it is the legislative competence to do so, and a beginning has to be made if the Constitution is to have any meaning. Unfortunately, it was, just kept in the cold storage for about 31 years since such a remark was made. It was only on 17th of June 2016 that the Ministry of Law referred the matter to the Law Commission of India to examine the matter in relation to the Uniform Civil Code. The Law Commission looked into the matter, and on 31st of August 2018, it had an occasion to deal with this issue. And the Commission firstly observed that there are certain universal principles with regard to the adultery, age of the consent, and ground of divorce that can be integrated into all the existing statutory provisions on marriage and divorce under the personal and civil code. While the procedure of divorce and grounds for the divorce, they may vary from community to community. The Commission also observed that, after referring to the case of the Saira Banu versus Union of India, which is reported in 2017, it observed that the issue of family law reforms doesn't need to be approached as a policy that is against the religious sensibility of the individuals, but it should be looked as one promoting harmony between religion and the constitutionalism. In a way, no citizen is left disadvantaged on account of their religion, and at the same time, every citizen's right of freedom of religion is equally protected. Broadly speaking, there are 6 aspects which requires, according to me, a further examination, which perhaps some of them have been taken by the Law Commission of India. The others my researchers have proved that perhaps there is a need to examine the issues relating to this. See, one of the important issue in this regard is, while considering Article 44 of the Constitution regarding Uniform Civil Code, the first issue, why should we have it, is the international covenant and conventions. If you look to the Article 16 of the Universal Declaration of Human Rights of 1948, it provides that men and women of full age without any limitation due to race, nationality, or religion have a right to marry and found a family. They are entitled to equal right as a marriage, during the marriage, and its dissolution. India is a party to this convention and is bound to give effect to the same. Even the provisions enshrined therein are in consonance and in conformity with our constitutional schemes, particularly Part 3 of the Constitution. If one looks to even Article 253 of the Constitution, read with entries of 10 and 14 of the list of the 7th schedule, This empowers also the Parliament to enact laws to give effect to the said declaration. Even otherwise, there is an assumption that Parliament doesn't breach the principles of international law, including the specific treaties obligation. Quite apart from this, Article 51C of the Constitution provides that the state shall endeavor to foster respect for the international law and treaty obligation in dealing with the organized people and with one another. A survey of the Indian cases clearly shows that international law and international conventions have to be used not only for interpretation of the statute, but also in the interpretation of the Constitution. Further, courts have heavily relied on the International Convention on the Right to Child, conventions on elimination of all forms of discrimination against women, and also International Covenant on the Civil and Political Rights, as is evident in the judgment, a series of judgments, including Menaka Gandhi versus Union of India, People's Union for Civil Liberties, Vishaka versus Union of India, and then the Municipal Corporation of Delhi and female workers. A number of cases. There are series of cases where such issues. So this is the one way, the one point which tries to strengthen about the article, our proposal to have the uniform civil code. The other issue relevant to this about to support the uniform civil code, because it is contained in Article 44 of the Constitution, which is the directive principles of state policy. Therefore, we must understand the relevance of the directive principles of the state policy. And here, I would like to mention one of the recent judgment of Supreme Court, which was delivered on 1st of October 2020 in Gujarat Mazdoor Sabha versus State of Gujarat, where Justice Chandrachud of the Supreme Court, he said that although the directive principles were not intended to be capable of being independently enforced before the court to invalidate a legislation, but according to the Honorable Justice Chandrachud, they inform state policy. They act as a guidepost for legislation. They provide a signpost for the travelers engaged on the path of understanding the complexities with the constitutional unravels. The fact that this distinction of justiciability is not now in the constitutional reality should not be allowed to obscure the more important fact of the directive principles and fundamental rights are both originally rooted in a vision of New India. I think this is what he was trying to emphasize was that there is a need to give, even though it is not a justiciable one, but it has to be read, and it becomes a very strong, important component of the Constitution. This brings me to another question: whether personal law, which is against public policy, qualify for the protection of the fundamental rights guaranteed under Article 25 to 28. And as you know, 25 deals with the freedom of conscience and free profession and practice of the promulgation of religion. Article 26 says about the freedom to manage religious affairs. Then Article 27 talks about the freedom as the payment of taxes, and then the last Article 28 deals with the freedom to the attendance of religious institutions. So long as there is a battle of sorts between freedom of religion on one and the right to equality, as it was said by the Supreme Court in Saira Banu versus the Union of India, recent judgment of 2017, that the court held that Section 2 of the Muslim Personal Law Shariat Application Act of 1937 falls squarely within the Article 13(1) which says that it is a law under Article 13(1), because earlier there was a controversy in that regard. Then the Supreme Court also said that giving affirmative answer to the question whether or not Section 2 of this Act, 37 Act, is violative of fundamental right, to the extent that it enforces the practice of the triple talaq, therefore it doesn't qualify the protection under the fundamental rights guaranteed under Article 25 to 28 of the Constitution. So I think this is a very clear answer to the same, and Supreme Court very clearly said that, also ruled that Section 2, though, which is a power, the procedure of dissolution of the marriage by triple talaq, is said to be derived, is declared to be, is void, and thus once it is struck down, as the arbitrariness of this procedure ceases to be a part of the personal law, and therefore it doesn't qualify for any protection on the fundamental rights guaranteed under Article 25 to 28 of the Constitution. Then there is another point from which perhaps one has to look into the question of uniform civil code, and that is, can a family matter falling under the criminal law be viewed as a problem of family law or not? And the Law Commission, in 227 report on the preventing the bigamy versus via conversion to Islam, had exclusively dealt with this issue. And the existing law on bigamy is, as you all aware, that Section 494 of the Indian Penal Code provides that a person shall be punishable with imprisonment, which may extend to 7 years. Now, in this regard, the question need to be said is that even so, therefore, my submission is that if once it is punishable under the Indian Penal Code or under any criminal law, I think family law should not come in the way. And in this regard, even so far as the polygamy is concerned, Pakistan, it has law that prohibits contracting the marriage during the subsistence of the earlier marriage. Even there are, it is the same in the position in Morocco, Algeria, Tunisia, Libya, Egypt, Syria, and Lebanon. All these countries, it is therefore suggested that Nikahnama itself should make it clear that polygamy is a criminal offense, and Section 494 of the IPC will apply in the same way. Same in the position about even under the Criminal Procedure Code, it was as it was held in earlier that on the question of maintenance also under Section 125 of the CRPC, one of the cases the Supreme Court clearly held that they are covered. However, later on, it was through some legislation it was given a goodbye for that purpose. Then perhaps we have to draw a lesson from Goa. Goa has what the constitutional framers envisage for India, a uniform civil code. It applies in marriage, succession, governing all Goans, irrespective of any religious affiliation. And I think just recently, Chief Justice of India had an occasion to visit Goa, and his observation, I quote, what he said is that Goa has what the constitutional framers envisage for India, a uniform civil code. It applies to marriage, succession, governing the Goans, irrespective of the religious affiliation. Courts of Goa have made a significant contribution in the development and law, and perhaps we have to draw a lesson from the Goa. Then there is another issue which needs to be examined, and that is right to adopt in this context of Article 44, and that is the right to adopt a child by person under Juvenile Justice Act. This is in Shubham Hasmi versus the Union of India, reported in 2014, The Supreme Court declared that right to adopt a child by a person as per the provisions of Juvenile Justice Act would prevail all over the personal laws and all religious courts in the country. I think these are all the says the how we can strengthen the Article 44, and perhaps of course the law alone cannot be a guide, but it cannot determine the same. We have to create say an environment for the same, but these are the issues which needs to be addressed while dealing with the question of Article 44, that is the Uniform Civil Code. This brings me a question about the reference was made about the COVID, and domestic violence is another issue which is really worried us. There is a phenomenal increase in the matrimonial dispute in the recent years, and the institution of marriage is greatly revered in the country. Section 498A of the IPC was introduced with avowed object of the combat the menace and harassment to a woman in the hands of her husband and her relatives. During the COVID period also, during the lockdown, there has been a surge of domestic violence. During lockdown, there has been an increase of domestic abuse in most of the state, and therefore coronavirus, the COVID has shown a need for radical overhaul of the national strategies on the domestic violence. I personally feel that so far the law, as you are aware, that law regarding the domestic violence in India is regulated by three major acts. One is the Protection of Women from Domestic Violence, that is 2005. The other is Dowry Prohibition Act, 1961. And then we have 498A of the Indian Penal Code. Now, there is a battle between the lawmaker and the police, and it has been reported that the power has been misused by the police officers while enforcing the same. In view of this, the Law Commission and the Police Commission and this court also, in a large number of cases, they emphasize the need to maintain a balance between the individual liberty and the societal orders while exercising the power of arrest. The Supreme Court in Arnesh Kumar versus State of Bihar, which is reported in 2014, laid down certain guidelines to deal with the cases relating to Section 498A of the Indian Penal Code. Firstly, it was pointed out that no arrest should be made only because of the offense of non-bailable and cognizable, and therefore the law of the police officers so to do. In the existence of the power of arrest is one thing, and the justification to exercise is entirely the different matter. So a number of directives were issued, and this brings me, say, related to the issue is about the impact on the child so far as domestic violence is, because they are the who are directly affected. So domestic violence is a serious issue. It can be physical, psychological scars, and therefore it leaves impression and is going to affect. See, it has affected to a very great extent the child. One of the recent development in the Indian family law is live-in relations, and with the ever-changing society and the human psychology, the concept of marriage and relationship has undergone. Also, one of the major development is the live-in relationship. When we talk of live-in relationship, its simply term can be explained as a relationship in the nature of marriage where both partners enjoy individual freedom and live in a shared household without being married to each other. It involves continuous cohabitation between the parties without any responsibility or obligation towards one tying them together, and consequently either the partners can walk off the relations. But recently, the Supreme Court has given its approval. And I think the starting point is Badmi Prasad versus Deputy Director Consolidation 1978. Here, the Supreme Court said give a legal recognition to this, and what the Supreme Court recognized the live-in relations and interpreted it a valid marriage. Similarly, the Supreme Court said that the legal status of children born from the live-in relations also, the Supreme Court provided the legal status to the children born in the live-in relations. And it was held that one of the crucial preconditions of the child born from the live-in relations to not be treated as illegitimate, and so that the parents may cohabitate for that. So therefore, they have given not only recognition, but they have given a right to property, even right in the property also to them. Then in Rameshwari Devi versus State of Bihar, the Supreme Court has gone a step further and said that they have a share in the pension and gratuity also. In that regard, this is a new development which is coming in the areas of what you call family law. Then Supreme Court also considered, insofar as the live-in relations are concerned, they said that it comes within the ambit of article of the right to life under Article 21 of the Constitution. This is a new development which is coming. And in landmark case of S. Khushbu versus Kanaimal, the Supreme Court held that living relations comes within the ambit of Article 21 of the Constitution. Coming to the status of women in live-in relation, the Supreme Court in Indra Sharma versus V.K. Sharma held that women appellants' status was that of a mistress who is in distress, a survivor of live-in relationship, which is a serious concern, especially when such a person are poor and illiterate. I think these are the issues which need to be addressed. Then I think there are a certain other issues which need to be addressed, and that is one of the important issues which has come up very recently that relates to the honor killing. According to the report of the Crime Statistics 2018 by the National Crime Record Bureau, there are 30 murders. There were 30 murders with the motive recorded in honor killing in 2018. And most cases went unreported. Number of cases have gone unreported. So I think in that regard, the landmark judgment, the Supreme Court in Sirman Chaudhary versus State of Jammu and Kashmir relied upon the Lata Singh's case and ruled that adequate protection should be provided to the couple who performed the intercaste marriage. I think a reference was made by Justice Mohan also. But I think since then, much water has flowed. And after that Lata Singh case, the Sirman Chaudhary versus State of Bombay, and the court is stressed that the increasing cases of violence and threat raises severe questions about the security of such couple. And there is no honor attached with the killing of the people for the sake of reputation of person indulging in such barbaric act needs to be severely dealt with. So I think this is how it has been dealt with. Even in later cases also, the Supreme Court ruled, even in Shafin Jahan versus Ashokan, the most popularly known as the Hadia's case, the Supreme Court ruled that right to choose to marry any person according to its will and the consent is an integral part of the right to life, liberty, and guaranteed under Article 21 of the Constitution. The recent development in the regard to the family law relates to the daughter's right in the daughter's property rights. Now, so far as this is concerned, as we all know, the law relating to joint Hindu family governed by Mitaksha law has undergone an unprecedented change. The said change has been brought forward, and in the section, even Section 6 of the Hindu Succession Act was amended in 2005. And since then, the Supreme Court had an opportunity to delineate the contours of the amendment. And in one of the important case of Denamea versus Amar, reported in 2018, the Supreme Court has held that a daughter who were born before the enactment of the Hindu Succession Act 1956 are entitled to equal share. The court also held that the daughters are entitled to the benefit of Amendment Act 2005, as well as on that basis, they are entitled to share also. However, in Vinita Sharma versus Rakesh Sharma, which is reported very recently in 2020, in August itself, the apex court held that daughters whose father died intestate before the amendment date also have an equal right in the property. And the apex court has held that the daughter has equal share in the father's property. This brings me to another area of family court, because family court are, there are recently, there are a lot of issues have arisen so far as the family court is concerned, because the object and reasons of establishing family court is to deal with the matrimonial disputes and informal settling. These are to break the rigid rules and procedures. But the drawback of the family court is that many of the judges as well as the lawyers are not equipped to handle the family disputes befitting the standards required. Delayed adjudication is another very important reason for this, which may be said to be defect. And Supreme Court in Mohan Singh versus Meena observed that delay in adjudication of cases by the family court is not only against the human rights, but is also against the basic principles embodying of dignity of individual. See, this brings me, there is another issue about the interim custody of child. That is a real concern. But the question is about in such cases, how to determine the best interests of the child, and Supreme Court has tried to look into that matter. Then there are other issues which pertaining to this family court, and Supreme Court has very recently said in 2021, only in March 2021, the apex court doesn't have a plenary power of the Supreme Court. This brings me a question of inter-country adoption, and there has been growing demand for the general law of adopting, enabling the same. And in this regard, the leading case of Supreme Court, which is a eye-opener, that is Lakshmi Pandey versus Union of India, where the Supreme Court has looked into the various malpractices that were prevalent in the system, and Supreme Court suggested a list of the reforms which need to be made so far as how to deal with the situation, and perhaps the government through various actions and by various notifications have issued how to enforce the orders of the Supreme Court, and the various guidelines have been set up for that purpose to give it a force. Then I think forced conversion is another issue which has recently received the attention, and on February 9, the Madhya Pradesh state government enacted the Madhya Pradesh Freedom of Religious Ordinance, commonly referred to be anti-conversion laws. And since its enactment 23 cases have been registered against the Muslim and Christians in Madhya Pradesh. How I now come, see, this is a very broad features which I have tried to say with a very broad brush. I have painted some of the issues arising this. My analysis shows that the process of interpretation of the Supreme Court has made a significant contribution in making a new jurisprudence in the family law. Thus, the court, in the process of judicial interpretation, brought judicial legislation on live-in relations, legitimacy of children, conferring property right to the daughters, illegitimate and even to the illegitimate children, and therefore, and also conferred property rights to the daughters and even to those illegitimate children born out of the void marriage or live-in relations. The Constitution of Supreme Court is also evident. Contribution of Supreme Court is also evident in the inter-country adoption, and among the recent contribution of the Supreme Court, as I've already mentioned, is the triple talaq, and to be a violative of the fundamental rights to the extent that enforces the practice of triple talaq, and therefore doesn't qualify for protection under the fundamental rights guaranteed under Article 25. Or thus, once the personal law is struck down, the arbitrariness of the procedure ceases to be a part of the personal law and therefore doesn't qualify the protection guaranteed under Article 25 to 28 of the Constitution. Be that as it may, I believe that much remains to be done. Time has come when the best practices of a reformed civil code in Goa may be adopted by other states, if not at the national level. The status of women is another key area that needs reform. I once again thank you so much for providing me this opportunity to share some thoughts. Thank you so much.
Can I put some questions, sir?
Oh, certainly. See, I'm here. So, yes.
In fact, after having heard you, I got the glimpse of a very learned professor talking to the students.
So nice.
And my question is only that what could be possible takeaway for the students from your presentation?
Okay.
Take away for the students so that they can work accordingly, not only after having finished the conference, thereafter also during their academic career, till they really wear the robe of an advocate.
Okay, there.
Right, sir.
Whatever help I can render, I will certainly do that. I think these are the areas which I have pinpointed. There are many other areas which I have left. I think in the course of discussion, I think I'll be able to explain to them.
Yes. Next, Isha.
Thank you for inspiring us with your valuable words, sir.
Now, I would like to warmly welcome our guest speaker, the Honorable Ms. Ingun Bog, founder and president, Female Wave of Change, USA. Ingun is an entrepreneurial woman who is always looking for new challenges. She has a wide experience in the corporate world, mostly in change management, education, sales, and marketing. After a career of almost 20 years, she started her own business in the beginning of 2003 because she became more and more aware of that she has living someone else's life and not her own feminine one. For the past 18 years, she has been an entrepreneur and advisor in different industries. Ingun is a connector and builds bridges between many organizations and people. She will always choose the human approach and builds future based on trust, respect, empathy, compassion, equality, diversity, authenticity, sustainability, and collaboration. We welcome you, ma'am.
Now, the next guest of honor is Saskia Harkema, CEO and Ambassador, Faces of Change and Female Wave of Change, Netherlands. Born in the Netherlands, She grew up in South America, Brazil, Argentina, and Colombia, and this had a great influence on her development and choices in life. Her working career shows her multifaceted talent and skills. With a degree in sociology, she started her career as a consultant and later international project manager, Europe at Philips Lighting, where she acquired hands-on and academic experience in the broad field of marketing and project management. Even later, she received a degree in business administration from the University of Bradford and made a switch to academia and education. In 2004, she finished her PhD at the University of Nederland in the Netherlands. In the course of the year, she have become an expert in innovation and entrepreneurship with both hands and on academic experience. We welcome you, ma'am.
Women make the world, save the world, and change the world. Some women justify this quote at its best. One of those personalities is present among us. Now, I would like to invite Ms. Mitra Chaudhary, Advocate, Supreme Court of India.
Hi, am I audible?
Yes, you are.
Thank you, sir. Should I just go ahead?
She is having expertise in labor and employment law, company law, civil law, and various other codes within law, especially environmental, women and senior citizens matters, enforcement directorate, NDPS matters, having 14 years of multifunctional experience spanning across banking, IT, NPOs, educational institutes, private and public sector, government projects in the fields of policy making, due diligence, audit and compliance, payments and settlements, RBI compliance, FEMA guidelines, IT law, etc. I would like to felicitate you with virtual memento on the behalf of MUIT, ma'am.
Thank you so much.
Now, I would like to invite you for addressing our audience, ma'am. Over to you.
Thank you so much. Thanks a lot for that wonderful introduction. And thank you everybody who's present for this webinar for giving me this opportunity. Family laws was one area that I never thought that I would be working in. And I thought that this is an area which has already been worked upon and there is a lot of work that is going on in this area. But accidentally, when I happened to enter into this, I have realized that there is so much work that needs to be done. And although there is a legislative intent, there are laws, but the implementation and the way the justice delivery system is working in this field needs a lot of correction and improvement. So in the pandemic, we have seen how the domestic violence cases had spiked up, and it had actually it came to the notice of a lot of people, including the UN, that domestic violence is like a shadow pandemic. So this was hiding for years, and we were not even aware that such a menace existed on such a wide spectrum. We know that the gaping loophole in our Indian judiciary is the backlog of cases. So consistently, courts are trying to resolve this, but we are dealing with a huge number of cases and a lot of backlog. These cases are dealing with broad spectrum of issues, including the family matters and property issues, which has been continuing for generations. So such cases continue for atrocious periods of time. We have seen cases going on from 7 to almost 25 years, which is a huge time frame. So in such a scenario, it was felt, there was a need that was felt that there should be separate cases, separate courts, channeling these kind of cases so that at least they are being dealt with effectively, and we ensured that there is a speedy disposal of these kind of cases. And that was one reason why the family courts came into existence. So the rise in the number of single nuclear families, breakdown of traditional joint family systems, there is increase in the case of divorces, there is migration to various cities for work, patriarchal societal setup, the attrition in traditional values, and the increase in number of working women or working mothers. Including the practices of dowry, including the recent trend of increased domestic violence and the neglect of children and elderly. There are so many reasons that contribute to a lot of issues that happen within the families. So to combat these kind of issues, I think it is important that we continue ensuring that the value system, the institution of the family, that our society has been setting up as an example. So we need a set of strong, consistent policies to strengthen our family system. Otherwise, we will not be left with any option but to counter with these increasing number of cases. So as Indian society, marriage is was considered as an institution. So marriage is not a contract, or marriage was not just an obligation, but it was considered as an institution. But now it has become a subject of great judicial scrutiny. So there are a number of provisions dealing with marriage and its various aspects, and there are various laws. So we have the Domestic Violence Act, we have 498A, we have Section 125 CRPC, we have child custody, we have various laws to counter with this. There is so much confusion when it comes to the implementation of these laws and the courts to approach to, not only within the aggrieved or the victims, but also within the legal community as well. So there are issues like alimony, there are issues like harassment to families, which have become a topic of great controversy. And further, the problem is the increasing number of fake cases. So I think it is important that the legal system needs to prep up for this. The younger generation needs to be more vigilant, or be, more. We have been talking about gender equality. We've been talking about a lot of gender related issues. So where all these things have been cropping up and where it is leading to. End of it, it has come to a situation where there was a huge fight and we had to set up specific family courts. Why there was a need for the family courts to come into existence? It was because of the building pressure of a lot of institutes which have been looking at the welfare of women. So welfare of women is needed because for years and ages, there has been a patriarchal setup, there has been prevalence of gender bias, there has been oppressive social practices, and looking at various conventions and UN treaties that we are party to, I think women have been denied justice and basic human rights. So establishment of family courts was an important step that was taken. It was basically to ensure to tackle the problem of pendency and to improve the efficiency of the system. It was not meant to change the entire system. Now, when the family courts came into existence, it was basically equipped with a lot of counselors and psychologists. So the main reason of having counselors and psychologists in the family court was that there might be legal issues. So marriage may be legal issues, but it also has a human and psychological dimension to it. And that's why it needs to be tackled in a way where our courts, our family courts, do give a lot of importance to mediation procedure. So although family courts are free to evolve their own rules and procedures, but they emphasize that the dispute should be settled by mediation and conciliation. So if a matter is solved by an agreement between both the parties, then obviously it reduces the chances of having further conflict. And this is another way that we want to ensure that the institution that we believed in so much remains to be. But then we have to look at the other aspect also of the adjudication, wherein a dispute can worsen if it is delayed over a long period of time. So we've all heard that justice delayed is justice denied, and I think if we stand by it and understand the issues, that if justice is not delivered in time, if there is no proper process in place, and if the victims or the aggrieved are getting harassed going to the courts, then it is not a solution. Then that is not a remedy. And then that is not a proper system, a good system. So I've been dealing with a lot of domestic violence cases and a lot of dowry cases and other cases wherein, women have been making rounds of courts either to get their maintenance or to get their basic rights. And it is so disheartening and disappointing to see how much time it takes for them to just get those basic rights, and by the time they get it, it's not effective at all, as in the need for it is not there. So the functioning of Indian courts has been very slow. This has been a matter of debate for a long time, and with COVID, it was severely impacted. Even then, the courts tried to cope up to it. Although during the entire COVID period, women, I think, have suffered the most. Still, the courts are coming back to its normal. There has been a point raised by Professor S.C. Srivastava, sir, about the Uniform Civil Code. Uniform Civil Code is, it's a very overarching concept in India, because it is basically talking about a common set of secular laws to govern all people, irrespective of differences in community, religion, and region. So when it comes to the Indian citizens, this actually supersedes the rights of the citizens to be governed by different personal laws based on their religious or ethnic identity. And this is something very difficult to work with, although I really agree that the Goan system has been appreciated and there should be common laws, whether it is marriage, divorce, adoption, property. But to tackle with different religions, regions, and community in India, this is going to be a Herculean task. So I feel that merely passing a central legislation is not complete in itself, and for implementation in its spirit, we have to ensure that there should be some level of uniformity. So even when we come to family laws, there's a lot of confusion, whether it is a civil law, whether it is a criminal law, and which act will fall under civil, which act will fall under criminal. So there's a huge mix-up, as in it is considered quasi criminal, civil kind of a act, which makes it very confusing, what courts to approach to. So sometimes you see marriage matters in civil court, sometimes you see 498 matters, obviously, which belong to the criminal, and then you see DV matters, which may go to the metropolitan magistrate, or it may go to the family court, or it may go to the Mahila court. So there is a lot of confusion when it comes to this. I think if the laws are put together and there is a clear procedure, as in, anything related to marriage, whether it is custody, whether it is property, whether it is maintenance, whether it is harassment, whether it is an act of crime, it should go to these particular courts. Probably that will make things more clearer for the victim also, for the legal fraternity also, and the confusion will clear, and probably speedy disposal will be more easier to achieve. So I feel that if we take these small steps and try to implement these, then the family courts would be more successful to a greater degree and fulfill a more noble purpose for which they were created. So these are some of the practical issues we face when we try to help the people who have been aggrieved with these kind of marital issues. With this, I just wanted to focus on the court system and what are the legal issues that we face when we try to counter something related to family laws. I close with this. Thank you so much.
Advocate Mitra, can I put a question to you?
Yes, sir.
You talked of the values for family system. how do we continue to reinforce those values, and what could be those values? And what could be outside the court to reinforce those values?
Right, sir. So I think for the values that you are talking about, the values about marriage as an institution and the values about the entire societal setup of India, why marriages have been working for so long in India and what has suddenly happened, what has suddenly come into our society that it is not working now. So that needs to be identified. The value is lagging there, where probably we are trying to enforce the idea of gender equality, but we are not prepping our children for that gender equality. So that could be one reason. So the value system at the family level, that is where we needs to first bridge the gap. And then, as you said, at the court level, yes, mediation is definitely a way, because in mediation also we need to have highly skilled mediators. So as of now, what is happening, the kind of trained or skilled fraternity that we have, I think their training needs to go a little higher and their sensitivity to issue needs to be increased so that they are aware how do we handle such a issue when something comes to them for mediation. So mediation should not be just a tick off the checklist. It should basically be a very personal approach, because every case is very different and we cannot have a straight jacket formula to handle each and every case.
Thank you.
Thank you so much, sir.
Thank you for your enlightening speech and triggering new ideas in the mind of our audience, ma'am.
Due to the shortage of time, I request each and everybody to restrict your time, please. Now, I would like to call Vikram Srivastava, Advocate of Supreme Court of India and founder of Independent Thought. We welcome you, sir.
Thank you so much. I'll try to restrict myself to the allotted 5 minutes. First of all, I'm very grateful to Maharishi University and the esteemed panel. We have the Vice Chancellor and the Chancellor and other dignitaries on the panel. It's a wonderful conference with an extremely important and relevant topic to start with. And within family law, I was listening to all the previous speakers and especially to Justice Mohan Pierce, and he referred to the 1994 UN convention, which talks about building the smallest democracy as family. And not that I don't agree to whatever the previous speakers have spoken, but I'm triggering a different debate altogether for the students of the conference. And so I'm taking a little different path, both to find more meaning and also as a kind of, a devil's advocate. So family, I also see as an institution of concern. I also see as an institution of oppression. I also see as an institution where a lot of things which shouldn't be happening happens. And I think Mitra ji shared about the patriarchal mindset. There were talks about how family engagements and the call for more democratization of family as an institution also reflects that it's lacking there at the moment. So what I like now to bring upon related to family and provoke thoughts among the students for their discussion in the next 2 days is the whole role and position of children within the family. And that's also an area of work for me as an individual and also for my organization called Independent Thought. And I thank again Maharishi University for engaging Independent Thought as one of the partners for the conference. So what I'll bring today is, in a couple of minutes, is that children as part of the family, somehow lose their identity. And that's a very, very serious concern. And why I'm saying this, because many of the times when we talk of children, the rights of children, even the UN conventions, even the government per se, brings family or parents as a kind of a camouflage, kind of a consolidated identity. And that goes against the rights of children. And why I'm saying so for two reasons. One, that the most of the cases of abuse of children, be it of sexual nature, corporal nature, be it forced into labor, be it forced into marriage, trafficking, all the problems you look at of children, you refer to NCRB data or 2007 study on child abuse, you will realize the data says it's mostly done by people around them. People who are expected to protect them are the abusers, are the perpetrators. And many of these instances are happening in the family. You just pick up any newspaper of any day, you will feel children being abused or otherwise are all by people who are known to them, parents, relatives, elder siblings. So I see family where children identity gets lost when we see the whole unit as one. So I think it's important for many budding lawyers to take up this issue of child rights, identify children, and prioritize their rights as your area of practice. Second, very important from a purely legal perspective, is the fact that the framers of the Constitution of India were very clear about this aspect, what I just said. And they have so beautifully crafted the part 3 of the Constitution. If you look at the part 3 of the Constitution, there is no mention of family or parent word. There is absolutely no mention. And children find very specific mention of them as individuals, children. And so if you look at specifically at Article 15.3 or now the later Article 21A, you find children have been specifically mentioned as individuals. And as students of law, you all know there's a rights and duty corresponding relationship. So state has a very, very straight, definite role when it comes to children. And this is what the Constitution of India mandates, that state must look at children as individuals and intervene if there is an issue of violations. Now, having said that, I will like to draw everyone's attention to a cause which we are fighting, is the campaign against child marriage. And in 2017, you all must be knowing, Supreme Court gave a landmark judgment where they criminalized sex with minor wives in the judgment Independent Thought versus Union of India. So that was our judgment by the Supreme Court. And since then, we are running a campaign. There are a lot of flaws within the family law, which takes or caters to minors and especially linked with child marriages. So we are now fighting in different courts on different legal aspects, looking for reform. So we have challenged the constitutionality of Section 198(6) in the Delhi High Court, which restricts filing of cases beyond 1 year of date of incidence. We are also fighting another case in the Supreme Court where we have challenged the whole provision of CMPO, Child Marriage Prohibition Officers, under the PCMA Act, which needs serious rectification. And coming to the Uniform Civil Code, I strongly believe India has traveled a lot in post independence, and it's high time that we realize the importance of a common law. And my understanding of religion-based laws is very simple, because it flows from a little patriarchal bent. It does kind of creates a or takes away the level playing field for different genders, and especially so based on age, based on sex, religion has a very different role to play. Men dominate in most of the cases, and so a uniform civil code is the way out towards creating what Justice Pierce was saying, building the smallest democracy. We must bring a level playing field for children who are discriminated because of their age and women who are discriminated because of the sex. And the only possible way is to bring uniform civil code. And even the UNCRC talks of children participation, which is a very, very less worked out area across the globe. So I'll rest here.
Sir, actually, due to time shortage, it's my humble request to you, kindly short your time.
I'm done. Thank you.
Okay. Thank you, sir, for your valuable presence. And
Isha, 1 minute. I think it's not right on your part to cut short the people who have come on the panel. You should have allowed.
No, sir, it's fine.
1 minute, Vikram.
No,
Let
sir, it's,
me do my part. Vikram was doing and bringing out certain important aspects for the learning of all of you. It is not right for you to intervene. If something is left out, next speaker is certainly me. And I'm locally available with you. In case even if I don't get a chance, I can always catch you and tell you what I want to tell you. So the people who are there on the panel and they have bothered, they have worked something for us, you should not cut them short. Please make a note. Thank you.
Okay. Please continue, sir.
no, thank you so much. I'll just end up by saying that when we look at family laws and family as a unit, as a social unit, and as the smallest institution in the social framework, and somebody said early on that we must look at laws as the catalyst for social change. I think somebody previously said that. So I think we must look at children as individual rights holder. And if we start looking children as the individual rights holder from the rights framework, and then see this role of the state and the linked accountability and all those stuff, then we give a very different meaning to the family law. So that's it. I extend my wishes to all the participants and all the students of the international conference, and I look forward.
University as patrons for this conference. Now, I would like to invite Professor Bhimsen Singh, Advisor, University Board of Governors. Professor Bhimsen Singh, who has been advisor,
उनको सिस्टम में बना रखा हो ये बच्चे हैं ना.
He joined Kirodimal College, Delhi University to pursue his PG in history. After getting admission in the year 1971, he has graduated in year 1971 from Patna University and joined DU Kirodimal College to pursue his PG in history. After his PG, he joined JNU Delhi to pursue his research project and received his PhD degree in 1975. We welcome you, sir, for addressing the audience.
Professor Advocate Group Captain O.P. Sharma, Distinguished Member of International Council of Jurists, Founder Director General, Maharishi University, India. We welcome you, sir. Born on 11 January 1938, Professor Group Captain O.P. Sharma, with 55 years of experience to his credit in the management of higher education, law, both teaching and administration, including research, in an eminent education with authorship of 23 books, formerly of Department of Judge Advocate General of IAF, he laid down his office during 1993. Sir, the stage is all yours.
I would like to share a few slides to you to give the preview what I intend talking.
Sure, sir.
This is family. And I happened to talk to my relation, my co-brother, who has been judge in the High Court of Delhi, and now the Competition Commission of India. I wanted to invite him to share his experience with all of us. He could not come, but what he said is this. Please see very carefully. क्या है यार? Next करो ना. This is not next. Kindly see this video. नहीं आएगा. Anyway, technical glitch. Right, what he said is, it is not being shown there, but I'll recollect. He said, Bhai Sahab, he's my co-brother. Bhai Sahab, where is family? Yes, of course, there are family laws and laws and laws. And when he said this, he struck a note for thinking on my part. I thought intensely on what he had said. Where is the family? We could not really resist in doing my own thinking, feeling, and also deciding what should I talk. You see this hammer and tongue with the family being beaten up, which means the administration of laws have ultimately created a situation where all of us, including the speakers today in this conference, lament that delivery system does not really fulfill what we expected it to be fulfilled. Why it is so? All learned speakers, one after the other, have been talking of one thing only. Other more than the delivery system of the court. That is what Honorable Chancellor said. Our chief guest said, Justice Mohan, that we must ultimately make our advocates work responsibly. Our guest, Dr. Srivastava, talked of many things which should have been happening. They are happening, and the role of the Supreme Court in particular for judicial legislation. We also heard other two advocates talking about what possibly could be done. My dear friends, just see at this slide, talking ethics, you must be crazy. I want all of you to be crazy. If we have to achieve really what for family laws have been framed, remember, caution, you will be isolated. Be good and you will be lonesome. If as an advocate, you talk of ethics, you talk of grace, you talk of dignity, it's a sad commentary on what is happening today. With due respect, because I am also advocate. I practice in Supreme Court and High Court as well. But when I see the things happening there, there's a fear of being lonesome. If you talk of ethics, you'll be termed as crazy. I sound a wake-up call. And wake-up call for all of us. What for wake-up? Wake-up is necessary for our family institution to be sustained. Justice Mohan talked of sacrosanct marriage, wedding. We are all aware of this. Rituals in all religions, they permit this. That is how it is sacrosanct. But do we really, either as a person engaged in the marriage, or an outsider, or in the court, do we really understand this part? And ultimately, what is happening today is the statistics in divorce are rising. One panelist talked of, I think by the last speaker, he talked of that family is the institution, is a school by itself. Basic values of which Advocate Sumitra talked are to be taught at the family by family itself. Gender sensitivity, where is that? All mothers are to be blamed. They must take the accountability. They have pepped up all their sons and not their daughters. So first thing which is required is that we as individuals, we as heads of the family, or we as advocates must understand this part, that our family has to ultimately sustain the family. That is unfortunately not happening. Further, coming to advocacy, my few guidelines are, kindly listen carefully. Whereas the family, yet there are laws, this is what I have scripted. Where is family? There are laws, and yes, laws. We shall examine the validity of this statement during this conference. This statement is extracted from the communication between me and my co-brother, member of Higher Judiciary and currently with Competition Commission of India, wherein I requested him to join us as guest of honor. Somehow he did not join in. The vitality and validity of this statement is indeed very relevant for all of us to examine. My thesis of family includes all that generates, develops, sustains, and eliminates, starting from generation of family till elimination. The bonding, whether later or whether inter or intrapersonal. Such stipulation is inclusive of marriage, including dowry, children, their custody, including adoption, maintenance, parents and their caring obligations. This aspect could not be touched so far. Elderly people, they are also part of the family. And the care which the sons are providing today to the elderly people. In fact, I am running an NGO with the name Omni Health Foundation, besides the call of the university and the law school and other educational institutions with which I am associated. What is necessary is that we must take on not only children, not only married people, elderly as well, within the frame of family laws. We must bother for them, we must worry about them. Living rights and duties, obligations, widows, after family is eliminated. Widows, their rights and duties, including inheritance on dissolution of relationship, all created through common law practices and specific statutes. Family law encompasses the broad set of rules that are in practice regarding family, which in my view is the validation of interpersonal bonding. Interpersonal bonding, giving rise of legally enforceable rights and duties, upholding the norms that are essential for human dignity. Take it from me, friends. There cannot be any human dignity without being crazy for ethics. When we talk of ethics, we must really consider to transform ourselves from being human to be humane. Human to humane. And friends, this E stands for ethics. Your own concern for your dignified living has to be so extensive as not to permit any unethical practice applicable for our all personal living as well as professional living. There is a changing perspective of family. We have heard very learned speakers on this. I have dealt with it in certain paragraphs. I'll skip them over, not required. I have already given the script to Professor Asthana, which will be put on the portal of the university and as well as will be given to all participants. The virtual now coming to what we should do as advocates. And take away, my dear students and the participants, from me in particular. There are two processes involved in our practice for the purpose of thinking, feeling, and doing. One process is consultancy, other process is counseling. Let me differentiate between consultancy and counseling, because most of us are engaged in both. But what is the difference? Consultancy is something advisory in nature for strategic solutions to the problem. Please remember, advisory in nature. Consultancy. Counseling is the process to find solution to the problem and be with the counselee to ultimately solve the problem. This is the difference. Most of us in legal profession in particular, or also in our personal callings, continue to be consultant. Consultant is a knowledge worker. Counselor is a wisdom worker. Difference between knowledge worker and wisdom worker is only one. That consultant is most of the time subjective. Hence knowledge worker. Wisdom worker most of the time is objective, and that is counselor. In the process of why do we have the mediation? Why Advocate Sumitra talked of what is happening in the courts, what is happening in the people, those who are even appointed as mediators have not been exposed in the right manner with regard to the counseling process. My strongest recommendation is from this webinar. Professor Asthana, please make a note to write to Government of India to create an institution of counseling with certain subsets for child counseling, for marriage counseling, marriage even before marriage, after marriage, before becoming parents, after having become parents, on becoming elder, on allowing the wards to be independent, because the life has to be the process of dependence to independence to interdependence. It is full circle, and we must not leave any area with regard to the counseling. It should be ab initio training. All students doing LLB course must undergo the counseling training, and thereafter there must be continuing education for advocates, for judges, for the people holding judicial authority. This is necessary to set up an institution on the pattern of NIPSID, National Institute for Public Cooperation and Child Development. We already have it. There's a need now, with the support from Professor Srivastava, the support from Justice Mohan, to ultimately create a legislation to have National Institute of Counseling, which will take care of all those aspects where we find today not in a position to manage them because they are unmanageable. And this management can be done only when each one of us is exposed to the process of counseling. Why we have these problems which are bugging us today? We have because we do not really are aware of the ins and outs of the counseling process. So my strongest recommendation is the counseling must be there, for which certain guidelines I have provided. They are available there, taking international perspective now. Professor Srivastava also talked of this. Justice Mohan talked of this, that inter-countries agreements got to be done. Really speaking, there are so many cases which I am dealing of the spouses. One of them is outside the country. They find themselves really at loss how to go about doing all these things. They ultimately look for guidance. Yes, we have certain guidance available. From Ministry of External Affairs, a lot of guidelines have been issued. And also we have guidelines from Ministry of Home Affairs. Because civil matters to be referred to the Ministry of External Affairs and criminal matters to the Ministry of Home Affairs. And from there, based on those guidelines, I've been trying to provide help to such cases where rift has taken place and disputes got to be resolved through the court only, and the counseling process probably has failed to deliver the necessary requirements. This is all which I would like to say. In the end, again, please take this wake-up call seriously. And we must do all that we can do on our part to introduce counseling in our style of living, whether personal living or professional living. With this, I would like to thank everyone who have joined us as panelists, and also in particular, Professor Asthana, Professor Bahal, and his team of students who have worked very hard for the last 2 months. In fact, I do not know if all the panelists have got this copy. This is the souvenir which they have issued. If you have not got, it will be dispatched to you. Kindly go through this. It will reveal the amount of hard work which is undergone. All the aspects which have been covered by learned panelists would find place in the technical sessions. My request to them is, if they could afford to attend those technical sessions, we will be not only delighted, we will feel grateful. With this, I would say good luck and Godspeed. Thank you.
Thank you so much, sir, for your kind words. Now, I would like to call Professor Dr. KB Asthana for vote of thanks. But before that, I want to give a brief info about him. He has completed his LLB for Barkatullah University. He did his LLM from Jayanarayan Vyas University, Jodhpur in business laws. He did his dissertation in banking laws and non-doctrine project on sanitation conditions around the Jodhpur area. He is having vast experience in law teaching, especially in family law, human rights, law, justice, and information, private international law, company law, banking law, corporate law, business laws, etc. He has written 4 books and many chapters in different books. He has presented many research papers in national and international seminars, conference. Clearly, more than 60 plus articles are published in different national and international journals and conference proceedings. Sir, the stage is all yours.
Very good afternoon to all. Thank you, Yash. Thank you, Isha. Yeah, definitely. Since morning you are working 10 o'clock and continuously it's being more than past 12 plus time. Really a very great work indeed. Yesterday we have seen that yes, practice session was going on, and I was quite satisfied that yes, indeed it will be a very great session. I deem it a great honor and privilege to propose a vote of thanks on this memorable occasion. Let me first of all start by giving glory to Almighty Guru Maharishi Mahesh Yogi Ji for making today's occasion a resounding success. Firstly, I thank to the person who is the authority of law and very humble person, Honorable Mr. Justice Mohan sir, who has given his valuable time in his busy schedule. As I'm remembering that when I have approached to Justice Mohan sir, immediately he has accepted my invitation. He said, definitely Asthana, I'll be there. And now he has shown the presence because he is the representative in UNO from Sri Lanka side. A round of applause for him. A leader and a great educationalist, having a great ideology, who have been always supporting to us with his blessing and encouragement always. He has blessed us for making this successful conference. A big thank you to Honorable Chancellor Sir for his continuous support and encouragement. I remember that when my student has went to invite Chancellor Sir, he was so happy, and immediately he has signed on invitation that yes, Bacho, I'll be there. A round of applause for Chancellor Sir. A leader and great educationalist and authority of family law and labor law, who has been awarded many times and contributed a lot for quality of education, for the education especially in family law, constitutional law, labor law, jurisprudence. He always remains available for his support. A big thanks to our Professor S.C. Srivastava sir for enriching the knowledge, accepting our invitation as a guest of honor and a keynote speaker. We are highly motivated, sir. A big thank you to you. A round of applause for him. I also express my heartfelt thanks to our mentor, Professor Advocate Group Captain O.P. Sharma sir, for his always supporting on every aspect to me, my faculty members and students. A big thank you to you, sir. A round of applause. I must not forget to appreciate his support our true leader, Professor Dr. Bhim Sen Singh sir, who has always supported us, motivated us, guided us, encouraged us for making a successful event. A round of applause for him. Definitely, last but not the least, I must thank to Vice Chancellor sir for his always support, motivation, guidance for this event. A round of applause. Thank you very much for Vice Chancellor sir. I also owe a special gratitude to Miss Ingunbol Dibok, Miss Saskia Harkema, Miss Sumitra Chaudhary, Mr. Vikram Srivastava. They have made their presence a round of applause. A big thank you to all. For making this international conference a successful conference, I also owe a special gratitude to Dean Academics, Dr. Ajay Kumar sir, Deputy Dean, Dr. Anugal Bahal Mera Madam, my faculty members, admin support, non-teaching staffs, IT support, who has always worked hard to ensure that this program will become a memorable program. A round of applause for them. I must also welcome to the distinguished participants, those who are going to take part in technical session 1, 2, and then technical session 3, 4, and 5 that will be held tomorrow, and the chair and co-chair professors from the different universities, especially from Delhi University, Lucknow University, Allahabad University. I welcome on behalf of Maharishi Law School, and thank you, sir, for gracing this occasion. Round of applause for them. Finally, I have this inspiration thought by Maharishi Mahesh Yogi ji. If we think of defeat, that's what we will get. If we are undecided, then nothing will be happen for us. We must just pick something great to do and then do it. Never think of failure at all. For us, we think now. That's what we will get. Thank you once again. Thank you very much, all.
Thank you so much. That's the end of the session. Thank you.